Hi, Tim Blankenship with Divorce661.com, and today we're talking a little bit more about the FL110, the summons. In the previous video we just recorded, we mentioned that it did change for 2014, January 2014. And I want to talk a little bit more about the standard family law restraining orders, which if you have a copy of the summons, it's on page 2. I want to talk about some of these restraining orders that go into effect and what they kind of mean. So what it says is, starting immediately, you and your spouse or domestic partner are restrained from 1, removing the minor children of the parties from the state, and then it goes on to a little more detail. Number 2, cashing, borrowing against, canceling, transferring, disposing of, or changing of beneficiaries of any insurance, and then it talks about the different insurance policies, transferring, encumbering, hypothecating, or in any other way disposing of property, real or personal, whether community, quasi-community, or separate, and then it goes on. Creating a non-probate transfer. Okay, so you can read these 1 through 4. So essentially, they don't want you to grab the kids and take out of state. They don't want you to cash or cancel or transfer as far as your insurances. So basically, you're supposed to leave on your spouse as a beneficiary until the divorce is concluded. As far as the community property and separate property issues, it basically says don't do any of these things, don't close accounts, transfer money, etc. But then it says without the written consent of the other party or an order of the court. So what I tell people is, aside from all these restraining orders, you can do all these things if you are in agreement with your spouse. That's really what that boils down to. So it doesn't mean you can't start dividing up your property while you're going through the process of divorce. You can, if you have an agreement that, hey, we're going to split our accounts, we're going to start selling off the cars and transferring title and doing those things, you're totally welcome to do that as long as it's by agreement. These restraining orders were put in place to protect one of the parties if someone was going to do something in a mean way to try and remove the kids or take them off of beneficiaries, or take all the money out of the account so there's no access to money by the other party. So that's kind of the spirit of the law of why there's these rules for the summons. But anything you want to do, for the most part, by agreement, you can do in dividing your assets throughout the divorce process. So I just wanted to clarify that. Some people, when they come in, they say, well, Tim, we want to start dividing up our stuff. It's totally amicable. And this says we can't do it. If it's by agreement, it's acceptable to do, because this is just between you and your spouse if this is going to remain outside of court. So there's no reason you can't start getting those things separated prior to the divorce being finalized. Tim Blankenship, Divorce661.com. If you need help with your divorce in California, please give me a call at the number on your screen or go to Divorce661.com for more information. Thanks for watching.